Good afternoon, authors, and welcome to the Negotiating Your Rights webinar, brought to you by the Authors Guild and the Copyright Clearance Center. My name is Michael Gross, and I am the Director of Legal Services at the Authors Guild. I have been with the Guild for 17 years, and in that time I've worked on over 7,000 legal matters. Joining me today is Ryan Fox, our Policy and Advocacy Director, who will also be assisting with answering some of your questions. Before we begin our discussion about book contracts, I want to encourage you all to apply for membership to the Authors Guild if you're not already a Guild member. As a Guild member, the Authors Guild's legal department will provide line-by-line reviews for all publishing contracts governed by U.S. law. What we don't do is provide line-by-line reviews of foreign agreements. We will, however, try to answer any specific questions a member may pose on a foreign agreement, although our answers would be based on U.S. publishing standards. Moreover, while the Guild cannot negotiate individual publishing agreements directly on behalf of an individual member, we do work with our members throughout the negotiation process to help them obtain the best deal possible. Even authors with agents come to us during contract negotiations for advice, and we are only too pleased to help out. Now, one may ask, why would I need to have my contract vetted by an attorney? I just want to get my book published, and that will happen if I sign the agreement presented to me by my agent, or I sign the agreement presented by the publisher directly to me. Well, the short answer is, publishing contracts can potentially strip an author of his or her copyright, or can pay royalties that are terribly low, and lock an author into a terrible deal that he or she has no way of getting out of for a long period of time. Yes, the author's book may be out on shelves and people may be buying it left and right from Amazon, but the author may not be reaping the benefits he or she deserves if they just sign whatever contract is put in front of them. For this reason, the Guild's line-by-line review is critical to authors negotiating publishing agreements, as it warns them of nearly every potential pitfall they will face if they sign the contract presented without negotiating it first. And this reasoning applies to why a member would want any agreement reviewed, even first-time authors with little bargaining power. Okay. Now that I've done my obligatory Authors Guild pitch, negotiating your rights in a book contract, we'll talk about negotiating your rights in a book contract and the purposes of this seminar. Today's presentation is intended to introduce you to some basic but essential ideas to keep in mind when negotiating your book contracts or when evaluating a proposal presented to you by your agent. Please follow along with the online presentation. If you have questions on what I'm saying, please feel free to type them into your browser, and I will try and answer your questions as we proceed. If you can keep the questions limited to the slide you're looking at, that'd probably be best. And if there's time at the end, we can try and answer more questions. However, some questions may be too complex or personal for me to address, so if I do not answer your question, please feel free to email your question to staff@authorsguild.org, and someone will get back to you. Okay, let's get started. What should I focus on first? When first presented with a contract, many authors feel understandably overwhelmed. There are so many potential issues to negotiate that many throw up their hands and just sign whatever is in front of them. I'm here to tell you there is no need to do that. Above all else, I think there are three categories that are most important for an author to focus on first. I think of the first category as the rights you as the author are asked to give up. These rights include ownership of your copyright, the grant of both primary and subsidiary rights, and how to terminate the grant of rights, which would be achieved with a solid out-of-print provision. The second category is the money you will receive for licensing said rights to the publisher, which includes the advance, primary rights royalties, subsidiary rights royalties, and the accounting and auditing clauses. Finally, the third category is the warranties and indemnities provisions. I will explain each one in turn. Let's first talk about copyright. The notion of copyright is actually embedded in the Constitution in Article 1, Section 8, Clause 8. This clause empowers the United States Congress to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Right now, copyright protection for individuals lasts for the life of the author plus 70 years. For the purposes of writers like yourself, Essentially, once you write something down or type it into a computer, copyright protection attaches to your words. As copyright owner, you possess the exclusive rights to make copies of your work, distribute copies of your work, perform your work publicly, such as for plays, film, dances, or music, display your work publicly, such as for artwork or stills from audiovisual works, or any material used on the internet or television, and to make derivative works, including modifications, adaptations, or other new uses of a work, or translating the work to another media. In the case of the author-publisher contract, you are licensing some or all of your rights comprising the copyright to your publisher, almost always on an exclusive basis. Now, as far as negotiating the copyright provision, you always want to make sure that the copyright is registered in your name. If the publisher manages to secure language to register copyright in its own name rather than your name, that is the equivalent of making the transferee, the publisher, into the author and cutting you, the actual author, out of all benefits to your work unless specified in the contract, when obviously the opposite should be the case. Thus, you always want to retain copyright in your name. Most book publishers are willing to allow the author to retain copyright in his or her own name, the exceptions being university presses, which sometimes insist on retaining copyright. Now, assuming you are able to retain copyright in your name, ideally, you want to require your publisher to register the copyright in your name within 3 months of initial publication. If your work is registered within 3 months of initial publication, you are entitled to pursue statutory damages and attorney's fees if the work is infringed. Failure to register within this time frame can result in your being denied these types of damages if your work is infringed. Finally, make sure that all licensees of your publisher are required to print a copyright notice in every licensed version they produce. We'll now talk about primary rights. Assuming you've retained copyright, you must next decide which rights you want to grant to the publisher for it to exploit itself. These rights are called primary rights. These days, most publishers are seeking to exploit both electronic and print rights themselves. Some publishers may also ask for audiobook rights, though it is best to insert a term of years, such as 2 to 3 years after initial publication, during which the publisher must exercise audiobook rights or forfeit these rights back to you if they fail to exercise them. Now, in regards to granting electronic rights, don't give up more than necessary. Ideally, you want to pin your publisher down to exactly what electronic plans it has for your work and what it will be exploiting. Ideally, you only want to license a verbatim text edition in electronic form so that the publisher can issue your work as a traditional true-to-form ebook. In regards to the print edition, you should try to limit the publisher's print publication rights to English language editions sold in the U.S., its territories, and Canada. If you have an agent or your publisher is small and doesn't have a foreign rights department, it may be in your best interest to reserve foreign rights for yourself or only grant them for a short period, such as 2 to 3 years, so that if they fail to exploit foreign rights within that time, the rights automatically revert back to you so that you can seek to exploit them yourself. I see we have a question on pen names and copyright. I'd like to defer that question till the end, and we'll talk more about that then. So moving along, we're going to talk about subsidiary rights next. When you grant subsidiary rights to your publisher, this means that you are granting your publisher the right to license the publication of your work either in its original form or in a different format from the original to third parties. We normally recommend that authors try to reserve non-print rights for themselves. Non-print rights include multimedia rights, film adaptation rights, television rights, radio rights, dramatic rights, theme park rights, commercial or merchandising rights, as well as foreign rights. This is especially true for authors who will be published by smaller presses, which may not have the adequate resources or the necessary experience or contacts to effectively exploit these rights on your behalf. For instance, smaller publishers may not have the connections or the bandwidth necessary to sell the German translation of your work abroad or option your work to a film production studio. However, if you do decide to grant all or some print, non-print, and foreign subsidiary rights, make sure that the grant is narrow so that your copyright stays intact. For instance, today we are seeing some publishing contracts that try to lump in every conceivable electronic right, including interactive multimedia rights, under what should be a basic ebook provision. Again, ideally, the publisher should only be entitled to license a verbatim text rendition of your work in electronic form. The right to license your work for other electronic uses, such as an interactive game, should ideally be reserved by you. However, by using over-inclusive language, such as all other electronic rights now known or hereafter invented, or in any electronic form, publishers thwart this basic grant so that they may rightfully exploit your work in ways that aren't even invented yet. So authors must be extra vigilant in negotiating electronic rights clauses. At the end of your subsidiary rights clause, it is wise to insert language stating that all rights not specifically granted to the publisher are reserved to the author. Next, we will discuss the out-of-print clause, which may be the most vital clause in a publishing contract. In regards to the majority of traditional publishing contracts, publishers will seek to retain the right to exploit your work for the entire duration of copyright, which we have already stated is life of the author plus 70 years. While the Copyright Act does provide a statutory right of termination, which begins at the end of the 35th year after the initial grant, most publishers will have lost interest in marketing an author's work long before then. Thus, the out-of-print clause is the only way for the author to regain his or her rights and seek republication elsewhere once the publisher has stopped meaningful exploitation of an author's work. Once an author's work goes out of print as defined in the contract, the author should have the affirmative right to demand that the publisher either reprint your work within 6 months of a written request to do so, or else reverts all rights, including electronic rights, back to you, the author. To this effect, when negotiating an out-of-print clause, the definition of what constitutes a work being in print or available for sale is key. First, make sure there is not a time restriction on when you can seek a reversion of rights. Some publishers try to stipulate that the author cannot seek a reversion until at least 5 years after the date of initial publication. The fact is, most publishers are done marketing and promoting a given work after 2 years from initial publication, so changing this period is key. Also make sure that if there is a time frame within which you cannot seek a reversion, it does not exceed 2 to 3 years. Next, you should define your work as being in print only when copies are available and offered for sale in the United States through normal retail channels in an English language, hardcover or paperback edition issued by your publisher and listed in the catalog issued to the trade by your publisher. With the rise of print-on-demand and ebook technologies, it is critical to include language that makes it clear that your book will not be considered in print if it is only available through these technologies. Failure to do so could prevent you from rightfully reclaiming your rights through the reversion process. To best protect yourself, we recommend stipulating that if your work is only available via print-on-demand or ebook technologies, it will only be deemed in print or available for sale if you, the author, receive a minimum floor in royalties over the course of 2 consecutive 6-month royalty periods, such as $250 to $500. Many publishers will seek to use a sales floor, whereby if they sell 200 copies over 2 6-month accounting periods, the work would still be considered in print. However, this method allows the publisher to heavily discount your work for sale to meet this minimum threshold and to retain control over all your rights. That is why using a fiscal floor is key to you as the author, as you are guaranteed a basic level of income throughout the life of the contract. I see some people have requested reversions of rights and were told it was being brought back, but they have not seen the reprint. I would encourage you to contact our staff if you are a member. We can help with reversion issues. Yes, so please contact our staff with your question. whoever had asked about the 18-month reversion, and we can get back to you. Okay, moving on. We're going to now talk about the money provisions, starting with the advance. As many of you know, an advance is a payment made to an author prior to the author's earning any royalties from sales of the work. The advance then offsets royalties earned. That is, the author won't receive any further monies from the publisher until the advance is fully recovered by the publisher, or earns out, as we say in the business. In theory, an advance is supposed to pay for an author's pre-publication expenses, which is why we advise members to either try to negotiate for a lump sum payment upon signing, or at worst, signing, delivery, and acceptance only, not upon publication or post-publication, which some publishers may insist upon, especially if the advance is large. As to the amount of the advance, historically, publishers have paid advances based upon the money they would expect to pay the author from the first print run of the work. Next, we will discuss royalties. But I do see some questions on retaining rights. Agents may say that you are not allowed to retain any rights. That doesn't mean you can't ask them to try to push, to negotiate to retain some rights. They should at least make a good faith effort. Any blanket refusal is not really representing your interests. They can at least try and make that effort known to you. Okay, that covers the questions we've got so far. Royalties. I put together a list of rates that you see that many of the larger adult trade book publishers are willing to pay their authors. Publishers routinely offer the following hardcover royalty scale, or I'll say the larger publishers do. 10% of the list price, also known as the cover price, on the first 5,000 copies sold, 12.5% of list on the next 5,000 copies sold, and 15% of list thereafter. For trade paperback royalties, many of the large publishers will pay a flat rate of 7.5% of list. However, some publishers may be willing to insert an escalator to 10% of list after 20,000 copies have sold. This escalator used to be very common, but now it's far less common, though it certainly can't hurt to ask during the negotiation period. For mass market paperback royalties, many adult trade book authors are able to negotiate 8.5% of the list price on the first 150,000 copies sold, and 10% of the list price on all copies sold thereafter. Now, many small to medium-sized publishers and even larger publishers, not named Simon & Schuster, Random House, etc., will insist on paying royalties based on their net receipts rather than the list price of the work. When a publisher pays on net versus list, the publisher has room to offer rebates or other special deals to purchasers, such as a bulk sale of various titles, or to write off bad debts of its purchasers, all without paying you royalties unless money actually comes into the publisher's hands. When trying to convert net-based rates to list-based rates, the general rule of thumb is that net rates are about half of the amount of list rates. Thus, if your royalty is 10% of the list price, you might try to negotiate a royalty of 20% of the publisher's net receipts to achieve the same dollar figure in royalties. Now, that being said, many of these small to mid-sized publishers will never agree to double their net-based rates, and often pay the same percentages as the larger houses that you see on this slide, except the royalties are based on net, not list. So, if you are unable to double your net-based royalties, but receive the royalty rates you see on the slide based on net receipts, you are really not doing terribly. Now let's discuss some special print rates. You will see the first rate I've listed is the rate offered by university presses. Generally, university presses offer royalties that are about half of the rates offered by adult trade book publishers. They also almost always pay royalties based on net receipts as opposed to list price. As far as children's book authors, their hardcover rates can be similar to those rates offered to adult trade book authors, but the escalation points may be higher, such as 10% of list in the first 10,000 copies sold instead of the 5,000 copies, 12.5% of list in the next 10,000, and then 15% thereafter. Paperback rates tend to remain the same for children's book authors. We'll next discuss some more special print rates, such as foreign rights. In regards to foreign rights, many publishers will reduce the royalties they pay on foreign sales of an author's work. Authors often receive, at most, 2/3 of their regular rates from export sales and as little as 1/2 of their regular rates. However, some authors are able to negotiate for their full royalty rates for Canadian export sales. One more point I would like to address is the fact that many publishers reduce their authors' royalties when they sell their author's work at what is known as a deep discount. The first thing you need to be aware of regarding a deep discount is what percentage will trigger this discount. If the percentage is 50%, there may be a problem, as a 50% discount is almost standard and could result in sales made to Amazon counting as deep discount sales. So the first thing is to make sure the triggering percentage is above 50%. Also, keep in mind that when a publisher sells copies of a work at a discount rate of 55% to 60% off the list price or cover price, many publishing contracts will automatically cut an author's royalty rate in half for these deep discount sales. The Guild takes the position that authors should first protect themselves by specifying in their contracts that the provisions of the deep discount royalty provision will only apply when the deep discount is given to a purchaser not ordinarily engaged in the business of bookselling and where it is not expected that the book shall be sold where books are normally sold at retail or wholesale. This is what is known in the industry as a special sale. In regards to the specific deep discount arrangement, and you may wish to write this down, so I'm going to say it slowly. You might try to stipulate that the applicable prime royalty rate will be reduced by 1/2 percentage point for each 1% reduction over your publisher's triggering rate. This is to say, the discount rate that would trigger the deep discount provision to be applied. Now, let's talk about an example. If the deep discount rate is 55% off the retail price, you might ask that your regular rate be reduced by 1/2% if it reaches 56%, and another 0.5% if it escalates to 57%, etc. It is also best to try to set a floor on your royalty rate for deep discount purposes, so that in no event will you receive a royalty less than 2/3 or at worst 1/2 of your regular royalty rate from deep discount sales. Unfortunately, many authors find that their publishers sell the majority of their books at a discount, so changes in this provision are important. Now, I want to say I know a lot of you people are typing in, can we download a copy of the presentation? I am not sure about that. That would be something that I think Casey or Ryan would have to address at the end. I know that if you join the Guild as an emerging writer or as a general member, you will have access to this information. Our model trade book contract is available, I believe, for emerging writers in an online form. So I would strongly encourage, if you want more information on this, to join our organization. Okay, let's next discuss ebooks. Royalties for ebooks, even those produced by university presses and small independent presses, are hovering around 25% of the publisher's net receipts at this time, although for years, publishers routinely paid 50% of their net receipts from ebooks. Honestly, we're not quite sure why publishers uniformly lowered this royalty rate, and the Guild has made its feelings well known about the lowered rate for several years. We feel the rate should have remained at 50% of net, considering ebooks save the publisher costs such as printing, shipping, and storing paper works. While you may be unsuccessful in getting the 50% at this time, you should definitely try to insert language that would allow for an automatic right of renegotiation after initial publication, such as 2 years from the date of initial print or electronic publication, whichever is earlier. Now, this is tough to negotiate, and a lot of publishers will not accept this, but they will insert language stating that if their general ebook rate changes, you would have the right to that higher rate if it's higher. I see someone had asked a question about what are net receipts of a publisher. Again, net receipts are what they actually receive, the money that comes in their hands, irrespective of who pay net receipts are what they receive, whereas list price is a flat rate that you'd be paid. If you get a list-based royalty, it's paid on a flat rate no matter what they get, meaning if the publisher has bad debts, they still owe you the money, whereas net receipts, if they have bad debts, they do not owe you the money. Okay, let's discuss next audiobooks. In regards to audiobooks, many publishers pay the following royalty scale: 10% of the publisher's net receipts on the first 10,000 copies sold, 12.5% on the next 10,000, and 15% of net thereafter. In regards to the downloadable electronic copies of the audiobook, many publishers pay much higher royalty rates, usually around 25% of net, but I've seen rates as high as 15 to 16% of list, which is about 30 to 32% of net. So negotiating audiobooks is certainly worth doing. We'll next talk about subsidiary rights royalties. An author's subsidiary rights royalty is your split of the income received by your publisher from all of its licensees who have licensed the rights in your work through the publisher. Almost all reputable publishers pay a minimum of 50% of their net receipts to the author from the licensing of domestic print-related rights, such as reprint rights, abridgment rights, or excerpt rights. However, most reputable publishers pay their authors a much higher percentage share of their net receipts from the licensing of foreign and non-print rights, including 75% to 85% of net for dramatic rights, which include movie, TV, radio, 90% of their net receipts for first serial rights, 75% to 85% for commercial rights, 75% to 85% for multimedia rights, 75% for foreign sales, and 85% for British Commonwealth. I see someone had asked, is it common for publishers to assign 50% against the advance? Usually the advance has to earn out in full. So all your income, whether it be from primary rights royalties or subsidiary rights royalties, will be paid. You will not get anything until your advance earns out. And someone asked to define net receipts. That's a good question. There is no legal definition of net receipts. It's what you negotiate in a contract. Ideally, you want to define net receipts as the gross receipts of the publisher less vendor discounts. But some publishers will try and take in, to account production costs, marketing costs, things like that, storage costs. If your definition of net receipts takes into account all these other costs, that means you don't receive money till the publisher earns back all these costs, and that can be a problem. So you really need to pay attention to how your publisher is defining net receipts if you're being paid on net receipts. Now, let's discuss accounting. Someone asked, what happens if you die before you've earned your advance? Again, that depends on the contract. Sometimes the contract may say that the agreement would terminate and you'd have to repay it. Other times the publisher may retain the right to hire another author to finish the work. It really depends on what you negotiate. So, talking about accounting and auditing now, our preference for accounting clauses is that the publisher be required to render royalty statements and payments at least biannually, every 6 months, if not quarterly, within 3 months of the close of a given accounting period. While many publishers have rigid reporting periods that are non-negotiable, keep the previous suggestions in mind, especially when it comes to their duty to render statements and payments within 3 months of the close of a given accounting period. In addition, be aware that some publishing contracts provide that if a certain amount of money is not earned by the author, the publisher's duty to render royalty statements and payments is stayed. The Authors Guild obviously objects to this, at least as far as the publisher's right not to render a statement. You should receive a statement regularly every 6 months as long as the agreement is in effect so that you can check the accuracy of your publisher's accounting, even if you earned a low royalty sum. Another common feature of the accounting clause is the publisher's right to withhold the reserve against returns. The Guild recommends that publishers be allowed to withhold royalties to cover returns for only the first 3 accounting periods, and that such withholdings not exceed 15% of the amount due the author, at least for the print edition. A lot of publishers will insist on retaining it for at least 4 accounting periods or 2 years, and they'll bump that rate from 15% to either 25 to 35%. I think 35% would be the top end of what I think is, I barely think that's reasonable, but that's the top end of what is reasonable. If they're trying to withhold more than 35%, it's, in my opinion, completely unreasonable. So try to make sure that your contract has that percentage in the agreement. Most importantly, you need to make sure your contract contains an audit clause. An audit clause allows an author to hire an auditor who may or may not be a CPA to audit your publisher's books to make sure it is paying royalties correctly and in full. Short of bringing a lawsuit, which, as you know, can be extremely costly, time-consuming, and stressful, the audit clause is the only way to contractually ascertain whether your publisher is correctly calculating your royalties, so its presence is essential. If your contract has an audit clause, be sure to stipulate that if you or your representative discovers an error of 5% or greater in any royalty statement, the publisher shall pay for the cost of the audit. This is fairly standard in the industry. See if there's any other questions. Someone had a question on if you get an advance, write and deliver the book, and the publisher doesn't publish it, do you have to pay it back? Again, this is a contract-specific question. If your book has been accepted and then they choose not to publish, and it's not due to the book being libelous or a fear of litigation, most likely you wouldn't have to pay it back. But again, this depends on what you negotiate in the agreement. There's not a hard and fast legal rule as to what must happen here. It's really up to negotiation. Okay, next we're going to discuss. Someone asked, oh yes, if you pay the advance back, you will get your rights back if the contract calls for it. Yes. Okay, we're going to discuss warranties now. A warranty is a promise that you make about the work you are delivering to your publisher. Typical warranties include that the work is original to you, the author, and it does not infringe another author's copyright, and that the work contains no libelous or otherwise defamatory or obscene material. Generally, publishers will be reluctant to negotiate their warranties provisions, but if you are able to do so, try to insert the phrase to the best of author's knowledge before any promises you make, especially those promises that pertain to defamation and obscenity laws. Legal standards for libel, privacy, and obscenity are especially confusing and can vary from state to state, and it would be difficult, if not impossible, for any writer to state with absolute certainty that her work does not violate obscenity laws in any jurisdiction. The most your publisher reasonably can ask you to do is to make a good faith effort to ensure your work does not violate such laws. Now discuss indemnities. Again, please keep in mind that your publisher will likely resist any but the most basic changes to their boilerplate indemnities provision. Nonetheless, you should at least inquire about the following changes. 1, try to stipulate that you would only be required to indemnify the publisher if a court renders a final binding judgment against you, stating that you breached the warranties contained in this agreement. 2, insert a cap in total that the publisher may withhold or recover from you if you are found to have breached the warranties. Ideally, you want to limit your liability to only a portion of your advance. However, this is almost certainly unachievable. If you are able to limit your liability to all sums owed under the contract, you'd be doing better for yourself. However, publishers are loath to cap an author's liability in most cases. Number 3, require the author's approval over any proposed settlement. And 4, try to get coverage under the publisher's liability insurance policy. Now, we've now covered basically what I consider are the most important provisions a first-time author should focus on when negotiating his or her contract. However, there are still many other contractual provisions that have important implications. Contractual clauses involving publication, manuscript delivery and acceptance, option works, competing works, and revisions to work as a whole, as far as future editions are concerned, are also important to address during the contract negotiation phase if you can. Let's look at publication first. In regards to publication, it is critical to make sure that there is a clause which requires the publisher to publish your work within a certain amount of time after delivery or acceptance. If the publisher fails to publish within this deadline, it should automatically forfeit its right to publish your work, and the contract should terminate immediately, with the author being entitled to keep the entire advance, even the portion that may not have been paid if the advanced installment was due upon publication. You really want to avoid vague language like, the work will be published with reasonable promptness, or the work will be published within a reasonable period of time after delivery or acceptance. Instead, ask for a date range in which the publisher must publish your work or else be in breach of contract and be forced to revert the rights back to you. Ideally, the publication date of the trade edition should be 12 to 18 months after you have delivered the manuscript, or at most after they've accepted it. However, many publishers insist on setting the publication deadline upon acceptance rather than delivery, and allow themselves up to 24 months to publish. This 24-month time frame is somewhat reasonable in our opinion, but an attempt to extend this time frame must be met with caution. Also, many publishers will try to stipulate that the publication deadline may be extended due to circumstances beyond the publisher's control. If you see this language in your contract, first, try to delete it so that there's a firm deadline, again, ideally no longer than 18 to 24 months after acceptance. If it will not delete this language, if it will not delete this language, ask your publisher to make the escape clause contained in the publication paragraph applicable to you as well. That is to say, you are allowed to delay submission of your work if war breaks out, a flood hits, etc. If the publisher will not agree to this, be sure to limit the applicable conditions to war, riots, fire, flood, and like events, not labor strikes or material shortages. The Guild feels that at most, the publisher should be allowed to delay publication only for the time covered by the conditions, but in no event for more than 6 months past the original publication deadline. Also, while you should be able to retain any amounts you have received if the publisher defaults on his publication obligation, these amounts should not be labeled in full settlement of any and all claims. If you have other claims against the publisher for their default in publishing your work, you should be entitled to pursue them. I see there's some questions about defining acceptance, which we'll get to. And someone asked, how does a publisher cover an author under their liability insurance, or how to get them to do that? You cannot force a publisher to cover you under their liability insurance, but you certainly can ask and push for it. Assuming they have a policy, they may be willing to do it. If they don't, you also have the opportunity to buy your own insurance policy. The Guild has a relationship with Access Pro where we offer media liability insurance to members, and it's at a pretty greatly reduced rate compared to commercial rates. As a member, you would have access to these rates. So if you do join and need insurance, you can apply for a free quote using our website. Okay. We'll now discuss some manuscript clauses. Most contractual provisions concerning the manuscript, acceptance of the manuscript is predicated on whether or not the manuscript is acceptable or satisfactory to the publisher. We oppose this sort of subjective standard, obviously, because it lacks any clear criteria and may even allow the determination to be made unfairly based solely on market conditions as opposed to the quality of the work delivered. We prefer that acceptance be conditioned on objective criteria, such that the publisher must accept the manuscript if it is deemed professionally competent and fit for publication. However, if your publisher does not agree to use this language, then another alternative is to provide that the manuscript will be accepted if it is editorially satisfactory. This will cut out the market conditions factor as a reason for the publisher to reject your work. Publishers may be more willing to agree to this phrase and allows them more flexibility, but it also provides the author with a little bit more degree of protection. Now, let's discuss some manuscript revisions. After delivery, the publisher should have a short and definite period of time within which it must accept or reject your work. Many publishers are required to render this decision within 60 days after delivery. If your publisher does not initially find your work acceptable, be sure that the contract requires the publisher to tell you in writing the ways in which it finds your work unacceptable, and be sure the contract affords you the appropriate time to make corrections or changes in response to the publisher's written comments. Only after you have submitted a second corrected draft should the publisher have the right to reject your manuscript. At this time, you should either be able to keep the advance, or you should be obligated to pay it back only out of the first proceeds you earn if you place this book with another publisher. Let's now discuss option clauses. An option clause gives a publisher a contractual right to potentially publish an author's next work even before he or she begins writing the current work under contract. While the Guild has historically advised its members to try to delete these clauses, many publishers insist on retaining an option clause. If you cannot delete the option clause in its entirety, you can try to limit its applicability by defining the option work, often referred to in the contract generally as author's next book-length work, as specifically as possible, so that the work is on the same subject as the one under contract currently with the publisher seeking the option. Moreover, you want to avoid being committed to submitting the whole manuscript. Ideally, you should only be required to give the publisher a summary or proposal of your next work, or at most, a proposal and a sample chapter. You also want to negotiate a period, you want to establish a negotiation period that is short and definite, such as 30 days after the publisher receives the summary or proposal. If an agreement cannot be reached within this time, make sure you are free and clear of the publisher and are not required to submit any other offers received so that your current publisher may match the terms. This ability to match other offers is referred to as giving the publisher a right of last refusal, which you want to avoid. We'll next discuss competing works provisions. A non-competition clause prohibits the author from publishing the same or a very similar work with another publisher. While the Guild advises that authors try to delete them in their entirety, again, many publishers will insist on retaining a non-competition clause in some form. To limit the effects of a non-compete clause, try to define a competing work as specifically as possible. Limit the time during which the clause is effective, as well as the media in which the clause is effective. If there's a project you know that you wish to undertake and you fear there is any risk that the project could violate the non-compete clause, it is best to get a specific acknowledgement from the publisher regarding this proposed project in the contract, and the fact that if you undertake such project during the term of this publishing agreement, it will not constitute a competing work for the purposes of the agreement. You can look to the sample language attached in the presentation for some examples, such as the author will not publish another romance novel using the exact same characters and dealing with the same subject that is intended for the young adult market, or the author will not publish or produce a work that is specifically intended to supplant this work in the marketplace. And also, I got a message that we will be following up via email with a link to today's recording if you want to hear any part again. So anything that you haven't been able to write down, you will have access to, and you can listen to it as many times as you want. All right. Finally, we're going to talk about revised editions. The decision to issue a revised edition almost always remains at the sole discretion of the publisher, not the author. Ideally, you want the decision to be mutual. That is, that you both agree, author and publisher, that a revised edition should be issued. If possible, do not permit your publisher to request revisions more than once every few years. Also, try to negotiate for an additional advance if you're going to be revising 20% or more of the original work. If you're unwilling to revise the work and your publisher has retained the contractual right to hire another writer to revise such, try to stipulate that her selection must be subject to your approval, not to be unreasonably withheld. Moreover, in no event should the payment of a new writer reduce your compensation below 2/3 of your regular royalty. Likewise, you should try to retain the right to review, if not specifically approve, the other writer's work. As to credit, your name should remain on the work unless you request its removal. Finally, and most importantly, try to stipulate that sales of the revised edition shall count toward royalty escalations. That is to say, do not allow the publisher to reset your royalties at the lowest level if your royalties are based on an escalating scale based on number of copies sold. Now, this concludes our basic presentation, and we'll now take some additional questions today. Again, I know some of you have submitted questions that were specific to your situation, and if we do not get to them, please send them directly to staff@authorsguild.org, and someone will get back to you. Now, I have some questions on my list I did want to address first. Somebody had asked, do we recommend publishers? Does the Guild recommend publishers? No. No, we don't. Not specifically. Though what we can do is check our database to let you know of any issues we have seen with other members, generally speaking. So if there's a publisher that you're considering and don't know anything about it, you can just send us a question, you know, do you have any negative history with this publisher, and we can look up and see what we've dealt, you know, see how we've dealt with them, and we can let you know, obviously, not specifically names of people, but like general issues. Now, someone also asked about translation rights in China and whether it was a big risk to license those rights. I mean, really, that depends on the Chinese publisher. I would not say blanketly that all Chinese publishers do not employ digital rights management technology. But at the same time, I would strongly advise you to look up, i.e. Google search, any Chinese publisher you are considering to see how other authors have fared. If you have an agent, I would advise talking to him or her about foreign rights in general before deciding to grant such to your primary publisher. Someone also had a question on foreign rights, whether distinguishing between exclusive foreign rights or granting exclusive foreign rights versus granting non-exclusive foreign rights. Now, many traditional publishers will only publish works if they can gain exclusive rights to those works. If you retain foreign rights on a non-exclusive basis, your primary publisher may be able to license the same work, which would basically compete with the work issued by whomever you license the rights to. This is something most publishers are unwilling to deal with. So generally, it's best to reserve exclusive rights if you are retaining foreign rights. Now, someone had also asked, if a book was a work for hire and there was no existing agreement and the book is out of print, can you get the rights to publish it? Now, first of all, a work for hire would almost, in most cases, be a written agreement, or if it was written as an employee, it would not. Now, any book that legally qualifies as a work for hire means that once you sign that work for hire agreement or it's done on a work for hire basis, the rights are no longer yours for the life of copyright. Now, if that company goes under or I guess basically if the company goes under or out of business, despite the fact that you originally wrote that, you still do not have a legal right to reclaim the rights if it's a work for hire. So, no. The answer is no to that question. Let's see if there's some other questions here that are coming in. Is it common now for publishers to insist on acquiring all rights, especially for fiction, or is it limited to small university presses? Honestly, a lot of publishers do ask for all or a substantial amount of rights. If you are going with a small POD ebook publisher, again, that's where you really do not want to grant more than what they'll exploit. Like if your publisher is primarily POD ebook, you want to retain all those non-print and foreign rights we discussed earlier, because basically they will not have, or it's very unlikely they'll have the ability to place movie rights. And I mean, they're just trying to piggyback on your success if you're successful. So no, you definitely want to be careful about what rights you grant. But yes, publishers will always ask for the kitchen sink, and if you don't fight back, they may get it. So you got to be vigilant.
Michael, there was a question about pen names earlier. Do you mind if I go ahead and give that a shot?
Yes.
Okay, so Sophia had asked about pen names, and the answer is you can do it either way. You can register your copyright under your pen name or under your legal name. There is a box on the application for pseudonymous, and if you're writing under a pseudonym, you click that box. Then you have the option whether or not to provide your legal name, and you get to make that choice. There are, however, advantages to giving your legal name on the application. It is proof of ownership. Your ownership can't be disputed in a business dispute if that were to arise later. But again, for some reason, if you do not want to reveal your legal name on the copyright application, do not reveal it because it will be on the internet. It will be a matter of public record. There's also a difference in copyright term, whether or not you give your legal name. If you do not give your legal name, you get protected 95 years from publication or 120 years from creation. But if you do give your legal name, then you get the standard copyright term of life plus 70 years. Also, that should answer that one.
Yep. Somebody had asked about publishers and Amazon. My understanding is that, at least with traditional books, you know, it worked similar to a traditional bookstore, whereas, you know, Amazon would get their huge discount and sell copies, you know, at the prices they determine. And depending on how your contract is worded, you'd either pay on the net receipts or the list price. I know that discounts to Amazon have ranged from, I believe, 48 to 52% at least. So that's why I make that point about the deep discount trigger, because there are I have seen cases where sales to Amazon could trigger that provision, and it becomes a huge point of contention. Somebody asked if the contract stipulates royalties of 10% of net receipts, 12.5% on the next 2,500. Is it unreasonable to ask for the same figures for list price? I would not say it's unreasonable, but I would say the publisher will probably say no. Again, most small and medium-sized publishers who pay on net versus list are doing that for a reason. They can't afford to pay you on the list price, which means that they can't afford to double those net-based royalties also. So most likely, you're not going to be able to convince them to do that. If anything, you might try to ask for slightly higher bumps, maybe starting at 12.5, and then 15, and then 17.5. I've seen that happen before, but they're not going to just convert to list, and they're pretty much not going to double the rates. You can try again to ask, but it's very unlikely you'll get it. Someone asked, is there any way I can find out the issues to be aware of in the contract between an author and an agent? Yes. If you submit the contract to us, we can look at the agency clause in the agreement. And more importantly, if you're a guild member, we do review agency contracts, and that is really where you need to be vigilant as far as the author-agent relationship goes, because what you negotiate in that author-agent contract is what will be in that publishing agreement with the agency clause. So yes, again, join the Authors Guild. If you have, you know, an agent contract presented to you, you'd qualify for membership, and we can review it for you and let you know the pitfalls. Someone asked, how do you know from a contract if a publisher is POD, or do you need to ask directly? I think there's a lot of factors. You can look online, see what they do. You can also ask directly. POD is print on demand publication. A lot of them, tout themselves as POD publishers. But you can generally tell. I at least can generally tell. You could always ask me. Right, are there any other questions we're missing here?
It looks good to me, Michael.
Does anyone have any other questions they want to ask?
Oh, Michael, here's one. How much leverage do debut authors have in negotiating?
That really depends on who the author is, and obviously the topic, the publisher.
But what we'd also want to encourage
often not a lot. What were you going to say?
But you should make the effort at least.
Yes. As I said in the beginning, yeah. Definitely try to negotiate what you can. The worst they can do is say no.
But they're not going to throw the project out because you asked.
99 out of 100 times, no. 1%, yes. Someone had asked, why in digital age do publishers retain royalty periods of pen and ink accounting of 19th century publishing? That's a great question. A, because it allows them to retain your money for longer. Even though the interest rate on small sums is very puny, if you have a large sum, it's obviously bigger. So the longer they can hold on to your money, they're gaining on that money while you're not. So they have no reason to change their system. Now, a lot of more modern or new publishers are issuing like monthly and quarterly statements, which is doable, and it's something that we applaud.
I would also add that this is something we've really pushed hard against in our Fair Contract initiative, especially in the piece we did on accounting and royalties. There is really no reason for this entrenched mentality of just keeping it the way it is when there are much simpler and more efficient ways to do things these days.
Yep. Someone asks, if you are a co-writer, often the author wants you to work as a work for hire. Do you have any tips for how to negotiate in favor of keeping the copyright for your work? Usually the Guild has to bow out of collaboration agreements because we believe, each author should be treated equally, and in that respect, we believe both authors should retain copyright. Now, I see a lot of times like one co-author wants to retain it at the expense of the other co-author, and we think that's unfair. But there's no way to force someone to allow you to retain copyright. But if they don't, it's probably not a project you necessarily want to take unless the money's really good. If the money's really good and you're still going to get, a cut of royalties, it may be in your best interest. But generally, the Guild has to advocate, for conflict of interest reasons for both the organization and myself as an attorney that each author is treated fairly. All collaborators in a project receive the same royalty or whatever royalty they agree upon. We will never advocate for one author getting more than another publicly. So yes. Rod, do you want to handle the illegal works on the internet question?
I haven't seen it actually. Would you?
Oh. When copies of your work appear illegally on the internet, who is responsible for finding and going after the perpetrator, the author or publisher?
Well, okay, so unfortunately it's either the author or the publisher. We've, taken a policy position that the internet service provider is probably better situated to actually track down these copies, but so far at least that we haven't had much luck there. So bigger publishers employ sort of rights management services such as Digimarc, and they sort of automatically look through these pirate sites for copies of authors' books, send automated takedown notices, and they're removed. Now, whether or not they pop back up again is another question. If you're not with a Big 5 publisher, then chances are you're going to have to do the policing yourself. Many authors prefer to simply stick their name to put up a Google alert, and that works for some people, but I've got to be honest, you're probably going to be seeing a lot more pirated copies of your work come into your inbox than you're comfortable with. The question then becomes, do you take action? The action here being sending a DMCA takedown notice, or what you want to do is to assess whether or not you think there's actual infringing copies on the internet, or this is a sort of scam site that's just trying to get your credit card information or something. It's really a case-by-case assessment. We do this all the time, so if you're a guild member, you can send this to us and we can take a look at it for you, also give you the sort of step-by-step process of how to send a takedown notice. So yeah, that's another advantage of guild membership, but it really does depend on who your publisher is and what you're comfortable with risk-wise and time management-wise also, because it can be a lot of effort to keep sending these takedown notices.
Great. Someone has asked, does an agent make a better contract more likely? The answer is yes. Most of the time, again, as long as the agent's reputable, they should have a firm grasp of, publishing contracts, and they should have strong relationships with publishers, where they should be able to get you better terms than you'd be able to get on your own. It's not always the case, but 99 out of 100 times it is. Someone also asked, when doing a second book with a publisher, will separate or joint accounting be specified in the contract? Generally, unless it specifies joint accounting, it's going to be assumed to be separate. It must specify joint accounting if it's joint accounting. And a joint accounting means that if you have a debt, that they could take that debt from monies due under the current agreement with that publisher or any other agreement you have with that publisher. It's basically called a joint accounting or cross-collateralization clause, and that's something the Guild strongly recommends to remove. You definitely do not want your books joint accounted, and sometimes I would consider that a deal breaker if they won't remove that, depending on your situation.
Let me follow up with Jason McDonald here. He asks that if unauthorized copies proliferate on the internet, can the failure to remove them make a work become public domain, even if they're unauthorized? The answer is no. There's an idea in real property that sort of not enforcing your rights can make a rights holder lose them, but that doesn't pertain in intellectual property. The copyright term exists for the life of the author plus 70 years, and it's the rights are tied up until that term runs. So no, by not doing anything, you're not risking the work becoming public domain.
Cool. Someone asked, does publisher give author right to choose cover, especially if the author is a designer? That would be something you'd want to negotiate in the contract. If you want to design your cover, you certainly can negotiate for that right. If you do not negotiate for that right, the publisher has no duty to let you design the cover. Do we review agreements presented by an agent? If that agent is presenting an agreement provided by a client, as long as that client is a member of the Guild, we will review it. We don't review agreements of agents' clients if the clients aren't members. Lori asks, is it better to self-publish or get a publisher? This really depends. There are a number of folks who've seen great success by self-publishing, some who have tried to traditionally publish for a long time and even have traditionally published are making more money self-publishing. To be honest, they're few and far between. This is the 1% where you're hearing these great success stories. If you do decide to self-publish, I would say you have to understand that you're taking on both the work of the author and the work of the publisher, and all the work a publisher normally does behind the scenes in terms of art direction, layout, copy editing, design, marketing, publicity,
readings. So yeah, you have to know what you're getting into, and you have to be prepared to do that work. That being said, if you are prepared to, then you know, you're giving away less of the cut. So there are advantages.
Somebody asked, if a publisher goes out of business, do rights automatically revert to the author? Technically, I mean, I think it would depend on the contract, but technically I don't believe that they would automatically revert. But at the same time, if the publisher is no longer an entity and they have not sold those rights to another business, and those rights, you know, are just, you know, sitting there, but there's no company, publishing company, really there'd be no one to object if you were to republish the work, since the publisher's out of business. So in a sense, the rights would revert to you if you're the copyright owner and the publisher doesn't exist anymore, but I don't believe legally it's automatic. I mean, realistically it's automatic, but I don't believe that it's just law that if the company is gone, the rights are now the author's, even though in the reality is they are, because there'd be no one to contest if you were to republish. Someone asked what percentage of first novels are agented. I couldn't even begin to tell you that. My overall impression is probably few. My guess is probably 10% to 20% at most. But I don't have the statistics to back that up. That's a shot in the dark there. I'm a literary translator. Do authors know we only get royalties if authors take less with the bigger publishing houses? If not, can we let them know to avoid a conflict between author and translator? Usually, at least in my experience with translators, the translator has a separate contract with the publisher than the author does. So, I don't think an author is going to accept lesser royalties to help you, the translator, especially if they have their own contract with the publisher. But, I mean, this all depends. I mean, sometimes authors directly license their rights to a translator if they retain the rights. You might be able to get as a translator, you might be able to do better that way. But I mean, authors are certainly not looking out for translators, in my opinion, generally speaking. The author wants to exploit their rights, and you're a tool for them to do that as a translator.
That being said, we've been working fairly closely with a small group of translators that are members of the Authors Guild. We're actually preparing a model contract for literary translators and some commentary to go along with it. So we are working with translators. Michael brings up a good point, though. You know, sometimes their interests are not exactly adverse, but not exactly aligned either. So it's a difficult policy position.
Yeah. Someone asked, what does a publisher require from an author post-publication? Again, that would depend on your contract. Often they may require you to do some marketing or maintain a website or do a certain amount of press. But that's all based on the contract. There is no, like, legal requirements that you have to do something unless it's in the contract. Someone asked, when a publisher says they want an introduction and they select the writer, is it normal to ask the book's author to give the intro writer a percentage of their royalties? In my experience, no. Usually the publisher would pay them if the publisher wanted a specific person to do it. The author should not be paying for that. If the author wanted to, obviously they could pay someone if they wanted to write an intro if that was what they wanted, but it should not be inflicted upon them. That's not traditional. Do publishers give the authors the right to pick the cover? Sometimes. Again, up to negotiation. Someone asked, is an agent better than a literary lawyer? Well, I think they really have two different functions. An agent really is there to help you get your work placed with a publisher. A literary lawyer is more of the contract guy. It's kind of what I am. I'm not one to necessarily place an author's work, but I can certainly look at the contract and negotiate that and have a better understanding of the legal implications than most agents. So ideally, you want to have an agent and a literary lawyer. If you join the guild and you have an agent, you will have a literary lawyer. So there you go.
I want to clear something up. Ray McDonald asked, what do you mean pirated copies will come into your inbox? I simply meant if you do sign up for a Google alert, then you will receive likely some Google alerts in your inbox saying that your books are available for free download on the internet, not that the pirated copies themselves come to your inbox. And that can be mildly distressing.
Someone asked, is it better to self-publish or publish traditionally? The Guild's old stance was always traditional, but we've modernized, and there are advantages for both. I mean, what I tell people is try to find a traditional publisher if you're inclined to do so. If you cannot and want to get your work out there, there are plenty of, I think, reasonable self-publishing options to consider. I think, it depends on who is interested in your work and, the topic and really, what offers you have. That's really what you have to decide as far as do you want to self-publish or, go traditional. If you have a terrible traditional publishing agreement, it's probably better to self-publish. If you have a great traditional publishing agreement, it's probably best to sign that. Someone asks, are there any other issues with a university press other than rights? I'd say rights, royalties again. You want to make sure you're getting paid as much as you can. You presses often pay less. Rights, royalties, and obviously you want to check out the warranties and indemnities provisions, the three main things. And, those are the main areas I'd focus on. And the other clauses we discussed, university presses have their own spin on everything, so it really depends on the press. Again, you can join the Guild. We'll review your UPress contract. We can tell you, if there's anything super out of the ordinary in there, and we can warn you. How much do agents expect to take on successful contracts? 15% or more. Generally, an agent's commission will be 15%. Sometimes it will escalate to 20% for foreign rights or non-print rights if they have to hire a sub-agent to place those rights. Some agents will try to get for more than 20%. We feel that's a bit greedy. 20% should be the cap, and it should require the use of a sub-agent to get that 20%. So if the agent himself is placing film rights and not hiring a sub-agent, the percent should still be 15%. If he needs a sub-agent, then it should rise to 20%. What services should a debut author expect from his or her agent? Again, you should expect the agent to advocate for you, to get your work placed with publishers, to get you a good contract, to advocate for your rights, while negotiating that contract, and if successful, during the course of the relationship with the publisher. That's what an agent basically does.
I would add that some agents do some editorial work, but that's not something you ought to expect. You should still be showing your work to agents in the best, when it's finished, as finished as possible.
Someone wrote, I heard that publishers no longer provide funds to send authors out after publication for PR, that the author has to do it himself. In a lot of cases, that's true. A lot of publishers won't give you money for that. Again, that is something that you want to negotiate in the contract, especially if you expect them to do that. It's a contractual issue, but the reality is a lot of publishers don't have money to do that. So that's the reality of the industry right now. Can your publisher sell your contract to another publisher? Again, depends on your contract. If the contract permits them to assign the contract to another publisher, then yes. If it requires your approval to assign the contract, then no. Someone asks for negotiation tips of the printing of color images in the interior of the book. You definitely want to make that part of the contract. As far as forcing them to do it, there is no way, obviously, to do that. But yeah, if you have like specific preferences for color images or things like that in the interior, you want them to be part of the contract. If you have specific paper you want it on, you want it part of the contract. When told a literary lawyer charges a certain fee, not by the hour, do you need to specify how many times a lawyer will review the contract? For example, it is understood that if a literary lawyer suggests changes and the publisher puts in changes, will the literary lawyer charge another fee to review those changes have been implemented? If contract negotiations go back and forth, are these additional reviews included in the original price given by the lawyer? Honestly, I think this depends on the agreement you reach with the lawyer. Some lawyers will charge a flat fee for the whole thing. Others will charge you by the hour from day one. So if they're charging by the hour, anything they're doing for you is going to be billed by the minute or half minute. I'm not even sure how it works. But yeah, they're going to charge you for everything. If you're paying a flat fee and to say you reach an agreement or retainer agreement where it's $500 to negotiate that agreement, the lawyer is obligated to negotiate in good faith. And I don't believe that there'd be a fixed number of times that he must adhere to or can choose not to listen to you before he can charge you more. I think that if it's a fixed rate, that rate stays fixed, if that's what you agreed upon in writing. Obviously, there's a reasonable person standard here, and there may be other implications I'm not aware of, but I haven't heard of any issues with a lawyer demanding more after they've asserted that it's a flat fee. Do publishers provide editors anymore? Yes, at least traditionally. Traditional publishers will edit your work because obviously they have to accept or reject it. For those POD ebook publishers, probably not. Any editing they would probably do would be minimal, and they might even try and encourage you to hire your own editor, or they might even try to sell you their editor. Yes. Ryan, do you have any idea about that SAAS question?
No, I know Stephanie asks in a typical royalty for print conversion to an SAAS subscription model. Stephanie, if you could give us an email at staff@authorsguild.org, we're going to have to do a little bit more look into that. I know SAAS is software as a service, but that's not something that I work with on a regular basis.
Yeah, we don't really handle too many SAAS agreements here, but I have seen them. But I don't know the answer to that question off the top of my head.
Yeah, if you can send us a staff@authorsguild.org, we can look into it for you.
Any other questions?
All right.
Awesome. That concludes our presentation. Thank you all for listening. Again, if you have questions, please send them to staff@authorsguild.org, and please consider joining our organization. You could join at www.authorsguild.org/join. All right, everyone. Have a good day.
Thank you.